Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of service law. To know more about it, please watch the video fully.
Now we are going to deal with the important judgment titled Pawan Kumar vs. Union of India and Anand, pronounced on 2nd May 2022. In this judgment, the Supreme Court has held that mere suppression of material or false information in a given case does not mean that the employer can arbitrarily discharge or terminate the employee from service. The facts of the case would be that the employment notice for appointment to the post of constable in the Railway Protection Force, including Railway Police Special Force, came to be published. The applicant being eligible submitted application form and participated in the selection process, and after qualifying the written examination followed with physical efficiency test, and after his final selection was sent for training. While the applicant was undergoing training, he came to be discharged by an order invoking clause 9F of the employment notice number 1/2011 and rule 67.2 of the RPF rules 1987. That became the subject matter of challenge at the instance of the applicant by filing a writ petition before the High Court of Delhi. The High Court upheld the order of discharge taking recourse to clause 9F of the employment notice number 1/2011 read with rule 67.2 of Railway Protection Force rules 1987. Being aggrieved, the present appeal has been filed. The Supreme Court has held that indisputably, on the day when the application form was filed by the applicant pursuant to employment notice number 1/2011, no such criminal case was either instituted or pending against him, and what was disclosed by him at the time of filling his application form pursuant to employment notice number 1/2011, there was no suppression of relevant information or submission of false declaration at that stage. It was unfortunate that a false criminal case of trivial nature came to be registered against him, and since it has no legs to stand as such before the charge sheet could be filed, the de facto complainant submitted his affidavit that no such alleged incident took place and the bag was found beneath the driver's seat itself, and under misconception a complaint was lodged by him. The prosecution witness has not supported a case of the prosecution during the course of trial, and for that reason the appellant was honorably acquitted by the trial court. Under the Railway Protection Force rules 1987, at the time of entry into service, a verification of character and antecedents of the incumbent has to take place according to the procedure prescribed by the central government from time to time. While a recruit is selected and before he is formally appointed, his character or antecedents have to be verified, and after due verification, if the recruit is found suitable for the post, may be considered for appointment as a member of the force. What is required that after the verification of character or antecedents of the recruit has taken place, it presupposes and casts an obligation on the appointing or competent authority to take into consideration as to whether the kind of suppression of alleged information or false declaration holds him suitable for appointment to the force in terms of Rule 52 of the Rules 1987. The candidate who intends to participate in the selection process is always required to furnish correct information relating to his character and antecedents in the verification or attestation form before and after induction into service. It is also equally true that the person who has suppressed the material information or has made false declaration indeed has no unfettered right of seeking appointment or continuity in service, but at least has a right not to be dealt with arbitrarily, and power has to be judicially exercised by the competent authority in a reasonable manner with objectivity having due regards to the facts of the case on hand. It goes without saying that the yardstick or standard which has to be applied with regard to adjusting suitability of the incumbent always depend upon the nature of post, nature of duties, effect of suppression over suitability to be considered by the authority on due diligence of various aspects, but no hard and fast rule of thumb can be laid down in this regard. By mere suppression of material or false information regardless of fact whether there is a conviction or acquittal has been recorded. The employee or recruit is not to be discharged or terminated axiomatically from service just by a stroke of pen. At the same time, the effect of suppression of material or false information involving in a criminal case, if any, is left for the employer to consider all the relevant facts and circumstances available as to antecedents and keeping in view the objective criteria and the relevant service rules into consideration, while taking appropriate decision regarding continuance or suitability of the employee into service. What being noticed by this court is that mere suppression of material or false information in a given case does not mean that the employer can arbitrarily discharge or terminate the employee from service. The bare perusal of the review order itself indicates that the authority has not applied its mind and just after a production of facts confirmed the order of discharge. Further, the authority has not even considered the scope and ambit of Rule 52 of the Rules 1987 that after verification of the character or antecedents of the incumbent, it will be an obligation upon authority to examine as to whether the incumbent or recruit is suitable to become a member of the force and without appreciation in a mechanical manner confirm the order of discharge. Thus, the order of discharge passed by the competent authority is not sustainable and in sequel thereto, the judgment passed by the division bench does not hold good and deserve to be set aside.